former President Donald Trump is celebrating a ruling that said that he participated in an insurrection. On Friday, a Colorado judge ruled former President Donald Trump could remain on the state's 2024 primary ballot despite engaging in insurrection against the U.S. and the Constitution. The decision came after similar lawsuits challenging Trump's ballot eligibility failed in Michigan, Minnesota, and New Hampshire. Now, District Judge Sarah B. Wallace in the Colorado decision said that while Trump absolutely engaged in an insurrection due to his actions before and during the Capitol riots, she does not have the ability, she claims that she does not have the ability under the 14th Amendment to remove him from the state ballots. So the 14th Amendment, Section 3, is a Civil War era clause that prohibits officials that have taken an oath to uphold the Constitution from holding office if they have engaged in insurrection or rebellion or given an aid or comfort to those who did. January 6th was an insurrection. So what's the deal here? Why did she not? Why has Donald Trump been allowed to remain on the ballots in these other states? Now, it turns out one of the issues here, at least in Colorado, is that Wallace says the president is not considered an officer of the United States and is not subject to the 14th Amendment's disqualification clause. So remember that was put into place to prevent former Confederates from running for office and winning in the Reconstruction South. And so Section 3, as I said, prevents anybody who has previously taken an oath of office, including senators, representatives, and public officials, from holding public office if they have engaged in insurrection or rebellion against the United States. So if you're a politician, theoretically, you participate or encourage rebellion against the government, you can either be removed from office and prevented from holding state and federal office in the future. So that applies to even president, vice president. How disqualification works under the 14th Amendment hasn't been entirely clear, and there's a lot of debate among legal scholars whether disqualification does apply to the presidency, even though it says in Section 3 that it does. So these legal scholars, these legal experts are, again, having this debate and saying, but can the president be, disqualified here? And in that ambiguity is where Trump is celebrating. In fact, Trump, campaigning in West Central Iowa, called the decision a gigantic court victory against an outrageous attempt to disenfranchise millions of voters by getting us thrown off the ballot. Our opponents are showing every day that they hate democracy. Well, wait a minute, that's rich. Considering the fact that, Judge Wallace actually rejected Trump's free speech arguments he was making to, egg on the rioters, essentially, and said that his actions meant that he engaged in insurrection. But what she's doing is kicking it to the Supreme Court. Now, Noah Bookbinder, president of the Citizens for Responsibility and Ethics in Washington, crew, who brought the lawsuit, addressed Wallace's ruling in a thread on X, formerly known as Twitter, and said the group plans to file an appeal. This is the first time a presidential candidate has been found to have engaged in insurrection. We are proud to have brought this historic case. Today was not the end of this effort, but another step along the way. Now, you have legal experts that weighed in on both sides. One is former Judge J. Michael Luttig, who took issue with Wallace's logic, stating that the former president is not an officer of the United States. So when I think of officer, generally you think of military, right? But Section 3 does apply to, again, senators and other elected officials. So, doesn't have to be a military officer here. And this is what Luttig is saying, quote, "It is unfathomable as a matter of constitutional interpretation that the presidency of the United States is not an office under the United States. It is even more constitutionally unfathomable, if that's possible, that the former president did not take an oath to support the Constitution of the United States within the meaning of Section 3 when he took the presidential oath to preserve, protect, and defend the Constitution of the United States." The Constitution is not a suicide pact with America's democracy. Indeed, it is the very contrary in its existence. It is plain that the entire purpose of Section 3, confirmed by its literal text, is to disqualify any person who, having taken an oath to support the Constitution, engages in an insurrection or rebellion against the Constitution. The former president did exactly that when he attempted to overturn the 2020 election and remain in office in rebellious violation of the Constitution's executive vesting clause, which prescribes the 4-year term of the presidency. Wow. So now Lawrence Tribe, a constitutional scholar at Harvard, took similar issue with Wallace's ruling, saying Judge Wallace held that anyone but a former president who did what she found Trump did, take an oath to the Constitution, and then break that oath by engaging in a violent insurrection, could never again run for any public office. So much for nobody being above the law. George Conway wrote in response to Tribe, "You mean you think it seems odd that the drafters of the 14th Amendment would have decided that an insurrectionist should hold no federal office other than the presidency? Or that the president is not an officer of the United States under a constitution that explicitly refers to the presidency as an office?" Look, all these are great points. Yes, the office of the presidency, clearly an office. But here's the thing about this ruling. I actually do think it works against Trump. How so? Well, look, when it comes to a factual issue as, decided on by the court, Trump did an insurrection. That's on record. The judge did not address the legal question of Trump's eligibility, but put out as a factual statement, Trump did insurrection. And when you look at the other cases, by the way, that were dismissed, that Trump is celebrating right now, kind of for similar reasons, right? For example, in September, Michigan Judge James Redford of the Michigan Court of Claims ruled that efforts to keep Trump's name off the ballot were not ripe for adjudication. What does that mean? A claim is not ripe for adjudication if it rests upon contingent future events that may not occur as anticipated, or indeed may not occur at all. So what exactly does that mean in plain language? Okay, so the anticipated event, or event that is in the future, would be the general election. Donald Trump has not won the Republican primary. So they're saying, why would we keep him off the general election ballot right now if he's not the Republican nominee? It might not happen. Republican voters might decide to choose someone else. I'm not going to rule on this right now. Come back later. So, and look, on November 8th, the Minnesota Supreme Court also dismissed the efforts to keep Trump off the ballot, but said, and this is very important, said the plaintiffs could bring a new petition regarding the general election ballot after the Republican primaries. Basically, this is the same thing. Like, we're not going to rule on a general election ballot before the general election, right? But before the Republican primaries are over. No. Let that play out first, and then we'll actually visit the legal question of whether or not he's legally eligible. So this question has not been answered yet. It is not settled, and very likely heading towards a higher court challenge. So I don't think Trump should be celebrating quite yet, because this could be, at the end of the day, setting him up for a bigger failure and embarrassment at a higher court.